All right, good afternoon and welcome to this month's second Wednesday afternoon break with Foster Swift. I'm Mike Cassar. I'm an attorney in our firm's Southfield and Lansing offices. I'm in our employer services group and I primarily practice workers' comp defense. For those of you who are new, we host this webinar on the second Wednesday of each month, and I or another member of our firm will interview another attorney in our firm about important and relevant topics in the law. And today I'm going to be interviewing our resident employment law expert, Cliff Hammond. Cliff is a shareholder in our Southfield and Lansing office, just like I am. He's experienced in employment law, labor law. He has extensive experience with handling matters in front of state, federal courts, state and federal administrative agencies, arbitrations, mediations, and he's a trusted advisor and counselor to his many employer clients. Today's interview is on a very relevant topic for employers in select industries. We're thinking about construction, transportation, logistics, healthcare, consulting, and IT services, and the gig sector like Uber, Lyft, DoorDash, Grubhub, etc. So we're going to be talking today about the U.S. Department of Labor's new rule governing independent contractors. Specifically, this new rule advises how workers are classified, either as an employee or an independent contractor, for purposes of compliance with the Fair Labor Standards Act. And what that act is, it's a federal law that establishes a minimum wage, overtime pay, record-keeping requirements for employees. Independent contractors are in business for themselves and they're not covered by the Fair Labor Standards Act. So we want to make sure who is properly classified as an employee and who is properly classified as an independent contractor. So we're going to talk about today. The Department of Labor's new rule became effective on March 11th of this year, so it's really new. It's really important that employers and workers are up to date on how this new rule applies so that there's compliance with the Fair Labor Standards Act. So with that short background out of the way, I want to welcome Cliff. Thanks for being here, Cliff. Here's the first question.
Thanks, Mike. So, ready.
Yeah, first of all, can you describe how the new rule provides guidance on how to evaluate whether a worker is an independent contractor or an employee? How's it structure this?
Sure. Yeah, I mean, it's pretty straightforward from a 30,000-foot view. It just gets more complicated when you try to scratch your head and say, okay, now how does that apply to this person or that person? So from a 30,000-foot view, what the Department of Labor said is, let's look at some factors that have historically been used, and let's try to apply them the way we think that you can look at an employee, look at an individual worker, and determine who is really doing the job. So we look at opportunity for profit or loss. Is the person actually using their managerial skill? The second thing they're looking at is, what's the investment by the worker and the potential employer? Now, what are you putting into this? What's a degree of permanence? Now, how long are you going to work? Is this a short-term deal or a long-term deal? We're looking at the degree of permanence, and the nature and degree of control. All right, we want to know how much control does this employer or this company have over the contractor or employee? What's the extent that the work performed is an integral part of your business? Now, this is one that might surprise some people. We'll come back to that in a second. And skill and initiative of the person. Nothing here should shock anybody because these are effectively what we've been using for 20 years, okay? These factors in general are the kind of things you're looking at. How much are you putting into the job as an independent contractor? Are you your own business? Are you controlling most of what your duties are? Do you have your own set of rules? You just get the job done. Is there an arm's length transaction? Do you have some skills you bring to the table that the employer needs and that's why they're hiring you? These are things that we look at all the time. And there's always factors in addition to that, which the Department of Labor looked at and said, look, there may be something in your industry that's unique, that sets you apart, and we'll take a look at that. But effectively, they're looking at the overall, how does this relationship work? And no one of those factors means more than the other. So we're looking at everything you do to determine, are you truly somebody who's independent, separate, working as a professional, who's invested time into your own business, that you're a skilled person and that you have a relationship that works? Or are you really just an employee who's just not having taxes paid out and you're just paying your own taxes? That's really what it's all about. Now, the problem is this is much different than the 2021 rules that were put out by the Trump administration. In that administration, they said, to be honest with you, this is pretty complicated because how are you supposed to juggle these factors and say, well, no factor means more than another? Well, which one do you want us to look at? It's all over the place. You know, you could see it from this angle or that angle, and this is pretty complicated. Let's just get to the core issues. And in those issues, they were looking at what's your opportunity for losing money or making money, depending on how much you hustle or how much your skill is as a manager as an independent contractor. And then they were also looking at things such as the permanence and predetermination of what you're going to do as far as control. Are you controlling and putting your thumb on this person, or are you not? Are you letting them do their job? So those core factors are really what you looked at. And then you effectively looked at the other factors almost the same as we just talked about with slight differences. So the change was small. The impact is large. Now, it's been a month since it's gone in. The world hasn't caught on fire because of the rule yet. But I can tell you it is massively different in its implications and in the nuance than it is from a 30,000-foot view. I'm going to tell you why. And this is really important. What's changed is how the DOL is going to apply it. If you go into the 300 pages plus of really exciting rules and the reasons why they did what they did, you'll see all kinds of examples, but I'm going to give you an example of what they didn't do. In the 2021 rules, they came out and had a couple examples of different types of employees. Let's just say, for instance, they had one about an owner-operator of a trucking company. In that case, the example was, look, if you have a person who owns his own truck, his tractor trailer, and he's driving for a logistics company, and the logistics company says, we're going to engage you as an independent contractor in your truck to deliver things, but we're going to install a GPS system on you, and we're going to actually control how fast you go so that you comply with the federal law. So in other words, it's got a limit on how fast you can drive your truck as an independent contractor. And after looking at that, they said, yeah, sounds like you're an independent contractor. That is something that was asked in the comment period when they said, well, wait a minute, can you explain to us when is a owner-operator an employee and when is an owner-operator of a truck not an employee and an independent contractor? And the Department of Labor said, no, we're not going to tell you that. It depends on the facts. Go ahead, look at our factors and figure it out yourself. Okay, well, that's not really helpful, but it tells you where we're at. They're literally saying everybody's different, and you could have multiple independent contractors, some of which may have the same contract, but their duties are slightly different, their responsibilities are different, their facts are different, and some could be employees, some could be independent contractors for the same company. That is confusing to some people, but that's why you have to take your time. This is a nuanced rule. And so let's go through some of these things I just talked about and talk about how they're really applying these. So, for instance, there's a question that was put by the Department of Labor. It says, how does this final rule differ? Okay. It looks at the cost to a worker which unilaterally imposed by a potential employer. And it says, if an employer requires you to go out and get tools, if they require you to go get training, then you can't use that as the investment factor to see whether or not they're profitable or not. Are they the kind of company that's investing in their own people or in their own self? That's a employer mandated investment, so it won't help you determine it. That's a big difference, because you would think if somebody is investing in their own tools, if they're putting money in their own training, that would show that they're independent, they're skilled. But what the Department of Labor says, not so fast. If you're only doing it because you were told you had to do it, that's actually not going to weigh for you. That's going to weigh against you saying they're an independent contractor. That's a big difference if you think about it for a minute. Let's talk about opportunity for profit and loss. That's something they look at, right? Very important. And it depends on managerial skill. What the Department of Labor said is whether a worker determines or can meaningfully negotiate the charge or pay of the work provided, whether the worker accepts or declines jobs or chooses the order and time in which the jobs are performed, whether the worker engages in marketing, advertising, or other efforts to expand their business or secures more work, and whether the worker makes decisions to hire others, purchase materials, and equipment and rent spaces, okay, can be relevant. Those are all relevant issues. They've always been relevant issues. So think about that when you're a contractor. Are they doing those things? But they said decisions to work more hours or to take more jobs when the person is being paid a fixed rate per hour or per job does not generally mean that they're going to be managing their skill. So what that means is if you pay somebody X dollars per hour under the independent contractor or X dollars per job, and the person starts taking more work on for you, that's not going to help you when you're making the analysis of whether they're actually have an opportunity for profit or loss. It's complicated, but what they're saying is it doesn't mean anything if a person's just going out there and working more for you. You could just simply be the person that they're working for. That doesn't mean that they're more of an independent contractor. In fact, they think that means they're less because they're looking for more sporadic, right? How about investments? And we just talked about it, cost of worker for their tools and their equipment. It's not going to go in your favor, okay? It's not a benefit for you. The degree of permanence of the work relationship. How does that work? Well, let's talk about it. Is the duration of your contract indefinite, or is it for a specific job or for a specific task? Non-exclusive, project-based, sporadic work is independent contractor type work, all right? But if it's only independent or if it's only seasonal, that's not going to help you in that argument, because if a person has a job that only runs because it's seasonal, that doesn't help you if you're trying to argue that it's sporadic. So where does that go to? It goes to the concept of if I hire a person and I call them a contractor to do a job, I have to look at all the factors that are going on. The question that you've got to keep in your mind is when you balance everything out, are they coming to this job and are they bringing anything that is of a sporadic nature? Are they open to get other jobs? Are they open to get other work? Or am I controlling them? What kind of tools, what kind of duration am I expecting? Are they coming back every year? Are they working with anybody else? What about the nature and the degree of control? This is really the crux of the change. When you had the 2021 rules, what basically happened was they said, look, we're not looking at what's in a contract. What we're looking at is reality. What's the economic reality? Is that person really working for you as an employee or a contractor? And here, the DOL is getting away from that. They're saying, look, what is in the contract is important too. If you reserve control but never actually use it, if you have a big flowery languaged independent contractor agreement that says you can do lots of stuff to them and control them and require them to do things, then you're going to be more likely to be an employee and as opposed to an employer or an independent contractor. So you can't sit there and have a contract that reserves control over how they perform the work in detail, the economic aspects of it. Okay, you look at the facts of what's going on in the contract and in place, actually what's going on. You got to look at the ability for the person to do their job. So for instance, and I think this has been going on for a long time, but a key here is, are you allowing the person to work for somebody else? If you have a restrictive covenant, like a non-compete, that is almost going to be a death knell for you, because they're going to say you're working directly for that person, exclusively for that person, and therefore you're controlling them as an employer. So buyer beware. If you want to get control and you want to protect yourself, that's fine, but you could have problems on that area. It's very important to understand if you are using technology, like we just talked about with the owner-operators, who may have some kind of device, the more you control, monitor, and watch somebody who's an independent contractor, the more likely you're going to lose the ability to argue that they're not an employee. The more you put rules in. And what this rule actually did was they went through an analysis and they said, look, we looked at all the comments. And what we've determined is if you're only going to put a rule in because it's statutorily or regulatory required, such as, say you're in healthcare, and there's a healthcare rule that says you have to have a background check before you can work with certain populations. Well, in order to comply with that rule, it's okay to tell the independent contractor you have to have that, or you have to have a specific license to do the work that they're going to do. They're fine with that. They understand that. That's fine. That's not going to weigh against you as being an employee. But the second you step over that line and say you need additional training, you need additional qualifications in the minimum, well, that's going to weigh in favor of you controlling them. And that's important to understand. What are you expecting your independent contractors to do and not do? So if you're using technology or individuals to supervise the job, if you are watching how they perform and you're telling them to do more than the law requires, you got problems. Okay. So it's very important. Now, another big issue I think that hasn't really been put out there, but I think most people who use independent contractors need to really worry about is, what does the person do? And I think this is critical. One of the 6 factors they're really looking at is, to what extent is the work performed an integral part of the employer's business? Now, this is always in another form than part of the analysis, but this is majorly different. So I want to get right into what the Department of Labor said. They said that this factor, okay, whether the work performed is an integral part of the potential employer's business, does not depend on whether any individual worker in particular is an integral part of the business. So it doesn't matter whether John or Susie actually is important to your business. The question is, are the functions they're performing an integral part of your business? It weighs in favor of the person being an employee when the work they do is critical, necessary, or central to the potential business that we're talking about. So if you hire somebody as an independent contractor that's doing something that is essential or critical to your business, the Department of Labor is saying that person has a strike against them being an independent contractor. So if what you do is build widgets and a person comes in and they help you build those widgets, it's going to be hard to argue that that person's not an independent contractor, unless we've got other factors on the other 6 factors, the other 5 factors that weigh against that. This is a major ground-changing deal. If you have no employees and a bunch of independent contractors, you're already, pretty much in trouble no matter what. But if you hire a bunch of people to do almost everything that's critical for your business, or you hire a couple people that are critical to the operations, even if that one individual can be interchanged, if the functions they're doing are critical, you got a problem. And I think if you take anything out of this seminar today, that's the one you've got to watch out for. You got to go back, and we'll talk about it more in a minute, but you got to go back and you've literally got to see, what is it that they're doing, not only in their functions, but what are they doing for you? Because that's now a new deal. That's a new issue. Now, this isn't like California's rules, which basically have a checklist, and if you check any of these particular issues, then you are an employee. The good news is it is still a totality of the circumstances. We're looking at everything, but you have to keep in mind, these are the things the Department of Labor is looking at. All right, they're looking at your skill and initiative. They're looking at additional factors, but I can't make it any clearer to when I talk to clients about this. If your real issue is about the fact that you have a person that's important, then you're in trouble. And if the person can't work somewhere else, if you're limiting where they're working, if they're only working for you, if you've got a contract that's going to be going on forever, if it's not project-based, if it's not limited in scope, if the person is economically dependent on you, all these factors go against that type of designation as an independent contractor. So we need to reevaluate, and very quickly, what we're doing, because the way that the Department of Labor is looking at is, look at 6 factors like we've been doing for a long time, but critical to that is, what is that person doing for your operation? And how is your contract based? Is it based on that person doing a job, or is that person being part of your operations and working with you for a long term? So it's a big change. And I think some people, I would just be honest with you, most people probably who have independent contractors are probably in trouble with the way they either structured it, or just the fact that they're not going to be able to get around it. So for instance, if I own an electrical company and I hire somebody to cut the grass, that's fine. If I own an electrical company and I hire people to come out and do electrical work, well, you got a problem, unless it's some sophisticated, above normal, it's not really part of your business. It's an add-on type of business. Even if I contract with somebody who does billing for me, the way that I just described the DOL's rules, we have to look at everything they do to see how the contract's structured, but that gets you in trouble too.
Yeah, that question was a big one, Cliff.
Yeah, I know.
Um,
I can go on and on
the,
and on, but I won't.
I know, but they're important things, and these six factors are incredibly detailed. And I guess we're thankful to the DOL for providing a few examples and roadmaps for how to analyze these things. But you've mentioned, if you're misclassifying either an employee or an independent contractor, you could
Mhm.
be in trouble. What are some of those repercussions of misclassification?
It's a good question. And people bring it up all the time. And here's what I do. I talk to people and I say, look, here's the thing. You got to do X, Y, and Z. And some people tell me, look, if I did all those things you told me I've got to do, I can't be in business. And I said, well, I don't make the rules. I just tell you what the rules are. And they have to make a business decision how far they want to go with their decisions. And I always tell people, you got to do it the right way. It'll come back, it'll help you out. And sometimes there's gray areas. But if you get hit, it's not like they come in and say, now knock that off. I mean, there's real world consequences. Now, most of the time, what you're going to do if you misclassify an employee, what do you think happens? Well, the person says, I work 600 hours a week, and so I'm entitled to overtime because you told me I was an independent contractor, so you owe me my $600, and you're arguing. And guess who has the responsibility to track hours? The employer. And guess what happens when you're an independent contractor in a relationship most of the time? You don't really always have the hours taken, especially if you pay them $6. Let's say I'll pay you $1,000 a month to do X. Well, I have no idea sometimes how many hours you worked. Now, sometimes you actually have a person who says, okay, well, I'll go ahead and bill you out X dollars per hour. So we have somewhat of a record. But either way, if it's more than 40, you get overtime and you get double damages most of the time. The law actually lets you get your overtime times two. So it's time and a half times two. How far does that go back? Usually 2 years. But if it's willful, so if you say, I don't care, I'm going to do whatever I want to do, well, then the government can come back after you for 3 years of overtime. And some people say, whatever, I don't care. It is what it is. It's the price of doing business. I got insurance. Well, most insurance policies you have for things like discrimination claims or things like that, most of those won't cover that. So that's money you've got to pay out of your business's pocket that you didn't anticipate. And you say, well, you know what? I like all these people. They like me. I like them. It's okay. And it's always good until it's not. It's always great until that person that you used to like, that's like divorce cases, right? We love each other and then they get divorced. They hate each other and it's nasty and it's terrible. And that's the way it works sometimes. And then they say, well, that's fine because they didn't work overtime. Well, did any of your other contractors, independent contractors, say they worked overtime? Because you can file a class action and you can either bring them in because they want to be there or they can be brought in because they don't. A person can file a charge with the Department of Labor directly and they can do an audit and look at all of your people and ask you all kinds of nice, fun questions. Come knocking. We're from the government. We're here to help. Just make sure you pay all your wages. Or they can get an attorney and file a lawsuit. And the Department of Labor can come in and they can actually file a lawsuit against you. And they're really nasty because not the Department of Labor isn't nasty. I'm just saying the lawsuits are nasty because what can happen is they can get attorney's fees if you bring a suit. So let's say you have a massive suit and you pay to defend yourself and they win a small amount, but a measurable amount for misclassification. And the attorney says, I spent 3,000 hours at $800 an hour. They could get much more in attorney's fees than they could even for the back pay. And oh yeah, by the way, there's also things like fines. You can get a class action suit. You can get a tax issue. There's $1,000 up to $1,000 per misclassified employee. And you can look at maybe taxes of 3% for misclassification, 100% of the FICA taxes that weren't paid, 40% of the FICA taxes, basically, back wages that they're going to get for you, and $50 per W-2 return that you filed that were wrong. There's even the ability potentially for criminal sanctions. I know the state of Michigan has an office about unpaid wages. They're looking at it criminally. Now, I think it's difficult sometimes when the federal government can't figure out who is and is not a independent contractor, and they're going back and forth every time somebody gets elected to say, well, why didn't you 20-person business know the rules when we didn't as the world's most powerful and wealthiest government? It's not the point. The point is, it doesn't matter. Those are some of the things can happen. So you can get fines, you can get sanctions, you can get debarred from doing government contracts in some situations, depending on what the contract is. You can have legal fees, you can have costs associated with it. You could have IRS investigating whether or not you pay taxes properly. Lots of fun stuff to think about. It's not an isolated issue, though. Now, does all this stuff happen every time? No. Could it happen? Absolutely. So you had to keep that in your mind when you're making decisions.
So potentially steep repercussions. That's serious stuff.
Yes.
Here's the next question for you, because you mentioned the 2021 rule from the Trump administration's DOL, and you mentioned there's slight changes in this new rule with big impact.
Mhm.
Um, is it possible that certain people were properly classified under that 2021 rule, and now they're no longer properly classified under this new rule? And how can we reconcile that? Are there consequences?
Yeah, it's almost a guarantee. That's exactly what happened. When the Trump rule came out, it basically was looking at a multi-factor test like we're doing now, which was the old test. Not exactly the same, but fairly similar to what we're doing now. And that rule basically said, look, if there were any questions, we're going to make it clear. It's going to be real simple. Focus on two core tests. And then after you get done with that, look at everything else. And let's look at the economic reality of what this relationship is. And then let's get to the other stuff later on about the performance and things like that. That's not the standard now. So by comparison, we have examples in 2021 that are now removed and most likely wouldn't be there. And again, what's the central integral part of the business that the operations does? I'm guaranteeing there's some people that are going to be on the fringes on those. So yes, the problem with this is at the end of the day, I heard there's something going on in November. I think it's an election or something of some sort. If there's a change in the leadership at the top, what reasonable person wouldn't think there's going to be a change back to what it was before, or at least a change different from what we have now? But that's the political nature of this business, and that's how laws get passed, and that's how regulations get passed. I think the best way to look at this is there's a chance it could go back. There's a chance it could stay the same. There's a chance it could be more aggressive. There's a chance of all that. But what we've got to do is kind of keep our eye on the prize here and say, look, let's look at what we're doing. Let's look what the factors are, and let's make a determination of what we think is going on as far as each and every individual contractor we have. And let's look at these new factors and let's see how it goes. And if the rules change, they won't change overnight. There's a long process that takes months, and you can come back to the drawing board and do that. There's actually a case right now. A number of businesses are involved trying to challenge this rule. There's a chance that the rule could be overturned. There's a chance some court somewhere could find that they didn't do this properly, that there's a technicality behind it. Happens very routinely with a lot of federal agency decisions, not just any particular administration, that's just the way the nature it is. Because a lot of businesses don't like this. A lot of businesses have decided that's not good. A lot of employees and a lot of contractors don't like this. A lot of people just love being a contractor, right? So there's different associations that are doing that. But where we're at right now is reality. And we have to adjust, even though it could change. It could go back overnight with a court ruling, or it could be changed through the process. But we're probably looking at something that's going to be at the earliest a year away if it were going to change. And most likely looking at a year and a half before it would change back. So the reality is this is where we're at. And this is what we got to operate under. And this is what you'll be held accountable by if the Department of Labor were to do an investigation. So I think we need to focus not necessarily on what could happen, because that could be too far away. It's what is happening.
Yeah, okay. So you help clients with this all the time, this classification issue. We have these new 6 factors. What do you recommend employers do to remain in compliance with this new rule? Considering all the things we've just talked about, the potential repercussions, what should they do?
Well, I think it's easy from me and my standpoint, and it's probably not as easy for everybody out there listening. I think you got to go get all of your contracts. You got to dust them off. You got to figure out what they say and what the people do, and we got to take an analysis of them. And we got to figure out, and we got to, I just tell clients, look, we have to take it from a new view. Every contract that was done in the past, it's up for reevaluation. Just because it was written when it was right doesn't mean it's right today. That's why I tell you, you got to reevaluate. Look, it doesn't matter if a person wants to be an independent contractor. This is strict. It's like paying somebody below minimum wage. You can't pay somebody less than minimum wage. You can't agree to it. It's just the law. So we have no other option but to go back and take a look at these piece by piece, person by person, not saying it's okay because we had them check a couple boxes saying, well, I agree, it's okay. That's not good enough. People sometimes ask me, can you just put some flowery language in there so we're okay? No, I can't. I mean, I can give you all the language in the world, but what they do is applied to these factors, and that'll tell you where you're going to come out. And there's some guesswork in here, right? There has to be, because we can make a position that this is right, and they can take a position just short of that saying you're not right, and we might have to litigate that. But for the most part, we can make a pretty good decision on where we stand. And I think it's important to understand that if you don't reevaluate everybody, you could have a problem, even if the person agrees, and even if it's never been a problem before.
Yeah, we've got a couple questions in the chat. There's a couple good ones. One from Robin and one from Tammy. And Robin's asking about real estate agencies with their independent broker agents, who they qualify as, or how they classify them as 1099s. I mean, it's hard to, I think, look at just that paragraph of information, Robin, and make a determination whether that's the right classification or not. These are really questions that you are going to have to talk probably with a professional about and go through those 6 factors, reevaluate the agreements that you have with those individuals. And I think I'd say the same thing to Tammy. Tammy says she's wondering about the building and department inspectors that they have working at their company and their classification. And I would just, and I'll tell Cliff to respond too, but I would say recommend reach out to Cliff and ask him, or your attorney, whoever it may be, and talk to them about this, because you want to make sure you have the right classification. So Cliff, based on those
real quick,
two,
Mike, on
yeah, go
that,
ahead.
on those two, it's really interesting because there are, like I said, there's 6 factors, and then there's that other and other factors. Now, for instance, in some agency, in some areas, there are IRS rules that say, look, these people are going to be independent contractors for the purpose of IRS rules. And I know that those are out there. And that's what some of the the different groups that represent different areas. So insurance salesman or maybe a realtor and things of that nature. They've been classified historically as 1099, and there are some rules. That doesn't necessarily mean that you are going to be okay for all laws. Remember, every law is a little bit different. And just because you're covered as an employee under the Fair Labor Standards Act doesn't mean you're covered as an employee under the Unemployment Act, and vice versa. Same thing goes for different industry standards. It could be an argument that in this industry, there are certain rules that make it this way. Could be in healthcare, certain types of jobs that a hospital would have with a doctor, right? Relationships historically. Same thing with a contractor. Those are individual. But what you need to look at is the totality. The totality of the circumstances is literally what they're saying is, let me know what you're doing, because it could be independent contractor with you, but it might not be because you do other things that outweigh the general restriction. That's why I say to you, that's what makes it complicated in application, easy to write, hard to interpret. And that's where we're at.
Yeah. Well, thanks for muddying the waters, Cliff.
Yeah,
This is all your fault,
not me, DOL, not me.
of course. If there's any other questions, you can either put them in the chat or reach out to Cliff or me directly, and we can try to point you in the right direction. That's it for today. Thanks, Cliff, for talking about that really important topic. I think we'll see, we've already seen a lot of questions about it already, and it's only going to continue to be an issue moving forward. So next month's session is going to take place on May 8th, Wednesday, May 8th at noon. We have our shareholder, Dora Brantley, talking about premises liability. And that'll be a really great session. Dora's she's been here about a couple years now, and she's a great shareholder at our firm, and we're really happy to have her on and talk about that topic with us. So if there's not any other questions, hope you have a good rest of your day. Take care.
Thank you.